Yes, okay, so in my book, my final chapter is trying to make the argument that Alexander Hamilton, like Jefferson and Madison, deserves to be known as a rights-conscious statesman. Okay, he doesn't usually get that credit, but he deserves it. And I talk about what I mentioned for you today, which is Hamilton and his loyalist practice, but then I bookend it with Hamilton's last big case, People versus Croswell. And People versus Croswell is a case about the freedom of the press at the state level, but under the U.S. Constitution and its Bill of Rights. And Hamilton absolutely comes out as an advocate for the freedom of the press, and particularly the way that the question of guilt is someone guilty of criminal libel or seditious libel should just be thrown to the jury so they can just have the entire question, which is not usually the common law practice. Usually the common law practice is you ask the jury about the narrow question of fact, which is, did this particular printer print the seditious material, and the judge decides whether or not it actually was seditious. So this is seen as progress, giving the whole question to the jury. The problem with, and I say problem because it's for students especially, it's not the tidy narrative we want to hear, because what we want to hear is that Hamilton and Jefferson and Madison, their conception of freedom of speech and freedom of the press was just as robust as we know it today, right? Everything belongs in the marketplace of ideas. And the reality is that's not how they felt. Instead, the People versus Croswell case is one of a few major stops along the legal history train, getting us from the British idea of freedom of the press, which to our standards is not free at all, though they thought it was, to where we are today, where you can say anything about a president, a member of Congress, anyone in state government, and you can't be thrown in prison for it or fined. And People versus Croswell represents kind of one of those transitional steps where, you don't get quite the freedom of speech result that a 21st century American would want, but yet it's still progressive in the sense that we're moving toward it. And when I teach freedom of speech in the Croswell case with my students, it requires a lot of background. There's a really famous New York case, colonial New York case, called the John Peter Zenger case, which is like ground zero of talking about freedom of the press. And you got to talk about that case, and you have to talk about truth as a defense. You have to talk about the law of seditious libel. You have to talk about the fact that there's the idea of possible jury nullification is a question, and that's what happens in Zenger. And then you got to arrive at Croswell with the addition of the First Amendment. And the First Amendment is read by men like Hamilton as just an extension of that common law tradition. So it's a really complicated story. But rest assured, it is part of the story that gets us to our robust conception of freedom of the press today. Yeah. Yeah, well, so Hamilton was all about that. So the Sedition Act, this is why this story is so complicated. Okay, so talking about freedom of the press, under the common law, the British thought that their freedom of the press standard was so progressive and robust because the standard was something called no prior restraint, which means you could punish speech after you make the speech and it's offensive, but the freedom comes in that you don't have to get a license to print your material in the first place. And truth was not a defense. If anything, if what you said was true, that was even worse. That was even more subversive to government. And like I said earlier, the jury decides this narrow question of fact. Okay, well, the First Amendment happens, and the Zenger case happened during the 18th century. And then we arrive at 1798 when genuinely the Adams administration and Federalists feel like we are in a crisis. There are all of these French immigrants infesting, they would have thought, our young nation. We're about to go to war with France. We don't want another French Revolution on our hand. And so Congress, the Federalist Congress, passes the Sedition Act, which basically says that if you say something bad about Adams, the president, or Congress, you are subject to a fine or imprisonment. But, and this is why Hamilton defended it, it incorporated these new progressive ideas that truth was a defense to the seditious libel prosecution, and that the jury would decide the total question, not a narrow question of fact. So Hamilton said, look at us, we've innovated on the common law, look at how liberty-loving we are. Jefferson and Madison, who on the opposite side of that, they're the Republicans getting thrown in jail for talking smack about Adams. They are the guys who are going to make the argument that the First Amendment goes beyond that common law standard, that old common law standard. At the polls, I'll quickly finish the story. At the polls, Jefferson and Madison win, right? Federalists are discredited, they're out of office. But now you have Jeffersonians in office, and what do they start doing? But they start throwing seditious printers in jail, which is why Harry Croswell's in jail, to get back to the Croswell case. And so now on the other side of the political situation, all of a sudden Hamilton is adopting a more progressive stance on freedom of speech. So this is it's a tricky situation, and as I said a moment ago, it's not an obvious progressive narrative to, yay, free speech for everybody, but it's an important step along the way, and the Alien and Sedition Acts are part of that. Yes? Okay, well, I don't think Hamilton would have condoned anything about the questions of federalism that secessionists used. I mean, Hamilton would have been absolutely all for keeping the Union together. And in fact, in the 1798-1799 quasi-war period, when states like Virginia were seemingly too politically opposed to the Federalist administration, he was like, we better send the federal army down there to keep them in check. So he was not about states trying to claim that they're bigger or better than the Union, or I don't even think it crossed his mind that they would actually seriously break away until Jefferson and Madison come out with their Virginia and Kentucky resolutions. So I would argue that if you were ever to trace ideas that allow for secession, that Civil War generations would adopt, back to the framers, you would cautiously have to do it with the Virginia and Kentucky resolutions, which Hamilton had no part of. However, I would also add that Andrew Jackson, who is an important figure in sort of the progress from early Republic to the Civil War period, Andrew Jackson, of course, was suspicious of the national government having too much power, but he relied on Hamiltonian arguments when it came to the importance of the federal courts to act as umpires and the importance of the national executive, the presidency in his branch, to be very strong and to have a lot of discretion. So in that sense, to me, that is sort of antithetical to what a secessionist argument would be come the Civil War period. So that's just a really complicated question. Yes, well, so the reason why I de-emphasize judicial review, and just to make sure, again, everyone is aware of the definitions here, judicial review specifically is the idea that a court can come along and review the constitutionality of laws and declare them to be null and void if they're unconstitutional. Now, the reason why I didn't spend too much time talking about Hamilton and judicial review specifically is because he didn't originate it. The idea that courts review the legality and constitutionality of law way pre-existed him in the English legal tradition. And so Hamilton, you know, he would use the idea that courts review law, but it didn't originate with him, and I was not trying to tell an origin story, and so when it came up, but I did not focus on it because of that. I would like to add, though, that the first case that goes before the U.S. Supreme Court where the US Supreme Court is reviewing congressional law for its constitutionality, and they determine it is constitutional, is the only case Hamilton argued before the Supreme Court. It's Hilton versus United States. My students, they always say, no, Dr. Brown, it's Marbury versus Madison. But that's the first time the court declared something to be unconstitutional. They thought the Carriage Tax Act in Hilton was A-OK. In the green, yes. You know, not that I can think of, generally speaking, Hamilton, you know, he knew that he thought courts should be what we expect them to be today, which is a protector of rights for everybody and not just toe the line and let majority rule take away your rights. So he expected that. That's part of his and others' arguments about the judiciary. But off the top of my head right now, I cannot think of an example of something you're describing when it comes to Hamilton's personal life or even something specific about enslaved persons. You know, I mean, Hamilton, he's a great example of somebody who of all of the framers, we associate him with getting rid of slavery because he was part of the New York Manumission Society. But as a lawyer, he was a thriving commercial lawyer, and sometimes that meant being an advocate for slave owners, and the transaction that he was litigating had to do with their slave property. So, you know, to your question, no, I cannot think of one. And sometimes from our modern perspective, he doesn't apply his own principles as far as we would like. That's not his fault, of course. He lives in the 18th century. So. Hamilton knew about state banks, right? He wrote the charter for one of them, Bank of New York. But Andrew Jackson did not like the Bank of the United States for a number of reasons, but for me it comes back down always to the law. And his number one legal complaint was that Article 1, Section 8 of the US Constitution, when Andrew Jackson, another lawyer, read it, he said, I don't see the power here for Congress to charter a bank. States can do it. In their state constitutions, it says you can charter corporations, but Congress does not have that same power. Hamilton, as you correctly said, you know, he's a Federalist, and so he has a different perspective on national power. When he reads Article 1, Section 8, he reads it differently. And he says, oh, I see enough flexibility in what is there to constitutionally support incorporating a bank. And that is the biggest disagreement between the two of them. Hamilton knew about state banks, but he did not think that the state banks could get the job done like a central bank could. Okay, yes? I reject and do not like to engage in sort of founding fathers, what would they do in today? And the reason is because after the New Deal and everything that happens with legislative power, the power of federal agencies, and presidential power over the 20th century, I do not think any of our framers or founders would ever have conceived of government so powerful. So I cannot possibly speculate. I don't think Hamilton would think it was okay, to be honest with you, because he didn't think that the federal government would ever be so powerful. So that is what I think about that. That being said, however, if you read Article 1 of the Constitution, which is the article that lays out congressional power, and you read, I should have brought my Constitution with me, I don't know, I don't have it. Article 2, which is executive power, and you read the way the articles are framed. Article 1, it specifically says something to the effect of the legislative power. Oh, great, thank you. Ooh, okay, all right, wait, let me. This is so good. I mean, I have it on my phone, but I don't have my phone up here. Okay, so I'm reading from Article 1, Section 1, okay? It says, all legislative powers herein granted shall be vested in a Congress, okay? Now, hold that in your mind. Now go to Article 2, and then it says, the executive power shall be vested in a President of the United States. The difference here is subtle, but Article 1 specifically suggests that the only power Congress has is herein granted. It's what's in the text, and that's it. You can read the text broadly, but you can't go beyond it. But Article 2, the executive power shall be vested in a president, suggests that executive power is much broader than what the text of Article 2 has in it. And so I would think that Alexander Hamilton, if an executive was acting in a way that resembled the King of England in the 18th century, that would be a-okay. Even if that meant, securing borders, if that's where it extended, because executive power seems to be very vast, whereas legislative power seems to be more contained. So maybe Hamilton would support some of the really strong executive features we see in our modern presidency, but like I said before, I don't think he would ever have contemplated a federal government even nearly as big.